The final topic that we've got to deal with is the second defence that's available. So just to remind us, what we've already established under negligence is that the defendant owed a duty of care, that they breached that duty of care, and that breach caused the harm. Now we turn to looking at what the plaintiff did, what the injured party did. And while they might not have voluntarily accepted a risk, the defence that we covered in the last video, what they might have done is contributed to the incident. And if so, we might be able to use the defence of contributory negligence. So what does contributory negligence actually mean? As the name suggests, it means that if the plaintiff was in some way responsible or contributed to the harm that they suffered, then the liability or the damages will be apportioned between the two parties. So in essence, they put some of the blame for the incident on the defendant because they were negligent, we've already established that, but they then also put some of the blame onto the plaintiff. And this is covered via Section 23 of the CLA. Let's have a look at Section 23. Now this can be a little hard to follow, so I've got the section here so that we can understand what's going on. So the principles that we need to apply when deciding whether a person has breached a duty, so these are the principles that apply to the defendant, right, the person who the plaintiff is arguing has been negligent. The principles that we apply to the defendant also apply in deciding whether the person who suffered harm, this is our plaintiff. The principles that are applied in deciding whether the defendant breached a duty also apply in deciding whether the plaintiff has been guilty of contributory negligence, where the standard required is that of a reasonable person, not that person, but the reasonable person. So again, it's an objective test about which they knew or reasonably to have known. So the principles that are applicable to the defendant also apply to the plaintiff. Those principles that we apply to the defendant are contained in Section 9. And so I've just flicked back to breach to Section 9, where you can see these are the general principles that we apply to the defendant. And they're the same principles that we apply to the plaintiff for contributory negligence. So this becomes the test for both breach and contributory negligence, including, of course, Section 9.2, which tells us what a reasonable person would have actually done. Okay, so hopefully that makes sense. Section 23 of the CLA says apply the principles that are in Section 9 when you want to judge someone who is guilty of contributory negligence. Now, in addition to the general test, there is a specific situation for when people are intoxicated. Notice we're using the word intoxicated here. It doesn't say drunk, so this would include drugs. It doesn't say someone's drinking, because you could have a sip of wine and not be intoxicated. It covers the case of being intoxicated. And if you're intoxicated, we come across a rebuttable presumption test. So we've run across this approach, this kind of test before, and what it means is it's presumed that you contributed. So if you're intoxicated, it's presumed you contributed to the actual event that led to your harm. You can rebut that with the facts, but it's a rebuttable presumption. So Section 47 of the CLA sets out that if the plaintiff was intoxicated when the event or breach of duty occurs, so this is when the defendant's breach occurs. So if you're drunk when the harm happens, contributory negligence will be presumed, and the plaintiff has to rebut that presumption. They have to show that either the intoxication didn't contribute or essentially that they were drugged, that the intoxication was not self-induced. Okay, so take aside the case of someone slipping you a Mickey. This means you've got to show that being drunk didn't contribute to the problem, or being intoxicated, because again, it could be other drugs. And not only that, it's going to reduce the liability of the defendant by at least 25%. So how does this principle actually work? I think the case of Manley and Alexander is a great one, a High Court case for us to think about this. And it was finally split. I think it was a 3-2 decision at the High Court. But what it involved was a tow truck driver who was driving down a carriageway, legal word for road. They're driving down a road at 4 in the morning. And as they look out, it's a bit overcast, etc., a bit rainy. They look out really early in the morning, very dark, and they see this guy on the side of the road. The driver sees this guy is kind of staggering around, and he gives a testimony that he thinks the guy looks a bit drunk. So he's watching this guy who he thinks is drunk over there. And then as he's doing that, he said he thought he was going to come out. So he went a little bit into the middle of the road. And as he did that, boom, boom, he hit something. He pulls over, and what was it? It was that guy's friend who's decided to lie down at 4 a.m. in the middle of the road to have a sleep, and he's run him over. Now, the guy who he runs over actually gives testimony that he'd had 12 small bottles of full-strength beer. So the guy's drunk half a carton, lay down in the middle of the road and have a sleep. So let's look at this, knowing what we know about negligence now. Did the tow truck driver owe a duty of care? Yes, motorists owe other road users established category. Did they breach that duty of care? What was it that they did wrong? What they did wrong was they were watching this guy over here not keeping their eyes on the road. So you've got to ask yourself, this careless action, is it reasonably foreseeable that if you don't look at what's going on in the road, you might cause a problem? Yes. Is that risk not insignificant? Is it a not insignificant risk that if you don't watch the road, you could hit someone and run them? Yes. Would a reasonable person have taken precautions? Okay, what's the probability of some harm coming? Well, probability of hitting someone is pretty high. The seriousness of running someone over in a tow truck is very high. The burden of taking precautions was very low. He just had to keep his eye on the road, or he could have slowed down or stopped if he was worried about 2 potential hazards. And there's no social utility in not looking at the road. So a reasonable person would have taken precautions. Therefore, he breached his duty to the pedestrian. So he owed the pedestrian a duty. He breached that duty. Did that breach cause the harm? Yes. Yes, the injuries were caused by the running over. So the tow truck driver was negligent. Okay, but that seems a bit weird, right? Because the guy lay down in the middle of the road at 4 a.m., which you could not expect, in dark clothing, by the way, I think the case shows. So that's where we now start to look at what that person did. And Section 23 says, if the person harmed, the guy who ran down, if he contributed in some way to the event that led to his harm, then he's guilty of contributory negligence. Oh, okay. So how do we work out whether he had contributory negligence? Section 23 says use the principles under Section 9 that apply to the defendant. So now what we do is we ask ourselves, for the person lying in the middle of the road, is it foreseeable that if you lie down in the middle of the road, you could get hurt? Is the risk of lying down in the middle of the road not insignificant? Yes, of course it is. Would a reasonable person in the position of the defendant, in the position of this guy who ran it, would a reasonable person have taken precautions? Okay, what's the probability of getting run over? Pretty bloody high. You're like 4 a.m, dark clothes, middle of the road, probability high. Seriousness, high. Burden of taking precautions. What else could the guy who lay down do? Could have lay down on the side of the road under a tree. Could have not lay down. Could have done 100 other things. The burden was low. Any social utility in lying in the middle of the road? No. A reasonable person would not have laid down in the middle of the road. Therefore, the guy who got run over contributed to the harm, and there was contributory negligence. I think, if I remember from the judgment correctly, they basically said that the person who lay down was 70% responsible for the incident. So even more responsible than the driver. So that's how contributory negligence works. You have to work out whether the defendant is negligent, then you look at what the plaintiff did, apply the principles that are set out in Section 9. Section 23 says to do that. So you apply the test from 9 via 23, and you could draw a conclusion. Of course, in this case, you didn't even need to use those principles. You could go straight to Section 47, which says that if you're intoxicated, 12 stubbies of beer, the guy was intoxicated. If you're intoxicated, it's presumed you contributed to the harm of the event. And so again, contributory negligence would arise under Section 47 via this intoxication provision. And if this section gets raised, again, it's a rebuttable presumption. So the guy who got run over would have had to have showed that his drunkenness had nothing to do with the problem. And of course, the only reason he lay down in the middle of the road was he was drunk. So he couldn't show that. And with that, we've come to the end of negligence. We've covered how you can work out whether someone is negligent, owe a duty, breach the duty, that breach must cause the harm. Then we work out is there any way to reduce the liability of the person who's negligent, either voluntary assumption of risk by the plaintiff or contributory negligence? And so now we're in a much better position to understand how careful we do need to be in business.